We are waiting for you. Hope this weekend was awesome.
All right. Good afternoon, everybody. This is February 17th, 2025. It's a meeting of the House Criminal Law Subcommittee. We have two bills on deck today, House Bill 21 and House Bill 437. We are going to start with House Bill 21. So, Chris, do you want to go ahead and bring in the folks that are here for that bill? And just to remind the subcommittee, House Bill 21 is the bill to reform the process by which one can file charges by way of a commissioner. And the bill is introduced sought to increase the penalty for bringing false charges and to have um, a law enforcement officer, I believe either a police or a state's attorney, be the one to ultimately bring the charges. There are several amendments, some that I tried to compile that were actually submitted by the sponsor. We had one amendment to alter the penalty further beyond what was in the bill as introduced, as well as a amendment that was discussed by State's Attorney Braveboy to contemplate shielding of these commissioner-driven complaints if there was not a conviction. The counsel to the committee, Claire Rossmark, wanted to translate some of that into the, I guess, the way they would have drafted it at DLS. So we are going to attempt to explain that. And Delegate Grammer also submitted an amendment in advance of this meeting to add clarification that restitution could be sought for people who were the victim of a false commissioner complaint, in addition to the penalties in existing law. All right, so that's a very brief review of where I think we are at. And I want to preface today's conversation by saying I did have a conversation with some of the state's attorneys, folks that are on this call today prior to the meeting, just to understand whether some of the amendments being discussed could be easily implemented and whether they could be done so across counties. And I will say that in that conversation, I did come across at least some disagreements or different perspectives among the various state's attorneys' offices about how they would choose to reform this process. And so it is my theory of the case that we ought to put forward a product in this subcommittee, if we do anything at all, that is something that is a consensus product that the state's attorneys broadly can live with and implement across the various types of counties. And so I want to also caution folks who may be disappointed if we don't do the full-blown bill, that I do suspect whatever we do, again, if we get something passed in this committee and across the street in the Senate, that we are likely in for a multi-step process and that it may take a number of years under which we reform this process. But at least for the purposes of this session and today, I am interested in whether we can get some step forward to at least reduce the number of residents who are subject to complaints that if and when they would be reviewed by a state's attorney, would clearly not go forward. So if we can get some progress this year, I would see that as a victory and a step forward, conceding that we may not be able to solve all of the problems for all of the types of defendants that came in and testified. Okay. So, and to reiterate, we had folks who were, the accusations were domestically related. We had others that had no domestic relationship whatsoever. We had strangers on the internet who were, did not actually meet each other in the physical world who were the subject of these complaints. And so, again, I don't know that we're going to be able to solve all of these case types in this year's bill, but if we can solve some of them, I think that would be a step forward. So that's just setting expectations there. With that, I would like to start the discussion with at least what I'm going to offer as a proposed subcommittee amendment that attempts to digest some of the conversations we've had on the bill to try and reach a first step towards whether we can find a consensus. Chris, if you're able to pop up on the shared screen what some of those amendments look like, we can begin the conversation. And this should have been emailed to folks in advance of the meeting. Let's actually do the penalty last, because I actually would prefer to focus on the crime limitations. Yeah, keep scrolling. Yes, this is it. Okay, so friends, before we get to the issue of the penalty, I just want to start this conversation off with a proposed amendment here that would narrow the bill. Again, this is just so that we can get something off the ground this year to start narrowing the use of these commissioner charges. And there was, again, there are folks here who can speak, I guess, with, we'll open it after a brief comment about what you're seeing on the screen here. But some of the state's attorneys, again, after the hearing, mentioned that they would not be able to do an immediate review of all of the cases that they would be asked to review if we did the full-blown bill. And so there was some concern that if it was a Friday charge and they didn't have the ability to look at it immediately, is there some public safety concern during that period where we're waiting for review? And so the proposal from the jump would be to narrow the bill by excluding a few categories of allegations from the reform. And that here is a crime of violence, a sexual crime, or a crime committed by someone who's eligible for relief under the Family Law Article 4501. So that's attempting to exclude some of the DV cases. All right. I see Delegate Embry's hand up.
Thank you. And I do understand the direction you've taken, and it makes sense. I just wonder, and I'd be interested in the state's attorneys, if it's still useful to have language about referring the warrants that are issued directly to the state's attorney's office. So at least that happens more immediately. I know they're available, but that they'd be affirmatively sent so that if you wanted to recall the warrants quickly, you could. That would be my only question / suggestion, but I understand and respect the direction of the amendment.
Delegate Grammer.
Can you explain what the amendment does one more time?
So if you're bringing a commissioner charge, the bill would only allow that to move forward by law enforcement review, but we would say this year we're not gonna alter the process if it's one of these three aforementioned categories: crime of violence, sexual crime, or if it's a potential DV case. And again, if you go back to the bill hearing, it's clear to me that this would mean the bill would not help some of the people who testified at the hearing.
So if I can comment, I think this is the point where maybe our feelings about the bill broadly kind of help us steer us in the right direction, if that's okay.
Yep.
Yeah, so my immediate thought about the bill was the text messages that we heard over the weekend from members of the committee, people threatening or harassing or threatening to assault referees at local baseball games, and the games getting canceled. And the testimony from that bill hearing, I think even the chair kind of mentioned, well, we have these commissioner, we can have that person go to the commissioner and file a charge. So I can already envision slews of cases where, hold on, I gotta get to an isolated room here. I can already envision tons of cases with this amendment of people who are just not going to have their issue heard, up to and including the people who are allegedly threatening and harassing umpires at baseball games. There have been a handful of situations in my district where it's a harassment charge, pretty egregious and pretty toxic, not necessarily physically threatening, but nonetheless like a criminal infraction that of a couple of young ladies where someone was frankly just being toxic to their life. It was a criminal violation. This would say they couldn't go to the commissioner and have their case heard. So I think for me broadly, I'm really afraid of removing this process in general. And I think even limiting it, the scope and capacity, you can already see like a ton of situations that are going to be extremely problematic. And while I think there are a lot of things we could do with the bill or in general to fix the process, I'm really just personally opposed to limiting the ability of the average person to have their problem put before a commissioner, to have charges investigated.
All right, let's go back to Delegate Embry quickly, and then we'll hear from the state's attorney's representatives. If that is your hand up, Delegate Embry.
Elizabeth.
I'm sorry, I wasn't responding. I just wanted to clarify, Delegate Kramer, that this just applies to the issuance of a warrant as I read it, and please nod or shake your head if anybody disagrees. So the charges would still proceed regardless. This doesn't affect the issuance of charges, just the issuance of a warrant. I just wanted to say that.
And that would be a warrant in the case where a commissioner agreed a warrant was necessary?
Right. They would not be allowed to issue it in those three categories. I mean, excuse me, they would be allowed to issue only in those three categories, excuse me. And in the others, they would only be able to issue charges.
Yep. I appreciate that clarification. Still seems horrible to me.
Okay.
All right. I think we probably had Hassan Giordano's hand up first, and then we'll go to Scott Schellenberger.
Thank you, Mr. Chair. Thank you, Delegate Emery. Yes, that it would be, that person can still, Delegate Grammer, go to the district court commissioner and file their complaint. That would be a summons as opposed to a warrant for their arrest, unless what they're issuing or what they're alleging is one of these three categories: a crime of violence, a sexual crime, or a DV related crime. Then they could issue a warrant as a court commissioner. Our office, under the leadership of Delegate Addison, has been supporting this from day one as our priority bill. We would have an issue with the crime of violence only because that is the number one issue that people go down and falsely raise. Oh, I saw a gun, but they have no pictures, no evidence at all of a gun, or that person hit me, but there's no evidence to the person assaulting them. They know that's going to be an immediate warrant if they say those type of words, those buzzwords of a crime of violence. In the case that Delegate Grammer is even saying, okay, this person may have assaulted me on the soccer field and threatened violence against me or my family. There's no evidence to that, but because they said that, now you're allowing a warrant to be issued, and there's no, if there is no evidence, and we see this, again, we talked about that 72-hour window, which I don't see in the amendments, that we would have 72 hours to see that evidence, and or that person is dismissed. That leaves a person arrested with a warrant for something they likely have never done. So we would respectfully ask to reconsider the crime of violence and or put that 72-hour window period, as the Delegate Emery was alluding to, sending it right to our office to allow our office to review it within 3 days, just to make sure that their evidence is there to sustain this level warrant.
All right, State's Attorney Schellenberger.
Thank you so much. So just to make sure, Delegate Grammer, to finish our answer to your question, it would only prevent the warrant. A criminal summons would be issued. So in that case, despite the fact that the referee may feel like, well, this is a very dangerous situation, since there probably is no relationship between them, the referee would be able to go somewhere and be safe. Whereas these crimes, crime of violence, sexual crime, and basically a domestic violence crime, there may be, particularly for the second two, B and C, a relationship. And therefore that may necessitate the need to take it up a notch and make sure that that the person will be protected by the issuance of a warrant. And that's why those are called out. Regarding the time period to review the case, I can tell you, and I talked to Delegate Moon, that would be a very difficult thing for my office. And we're a big office, and some of the smaller ones, it would be even more difficult to be able to review these cases in such a short period of time. We don't have, the central district like the Baltimore City State's Attorney's Office has had for a very long time. And it would be really difficult to put a time limit on how quickly we would have to look at it. I would need at least one additional ASA to work on those problems.
And actually, can we have Patrick Gilbert from Wycomico weigh in before we roll back to the members?
Good afternoon. Thank you, Delegate Moon. I just want to clarify one other additional thing, Delegate Grammer, that this doesn't per se preclude the issuance of warrants in the type of context in which you're describing. Maybe a referee gets, an alarming and threatening text message. If that referee goes directly to the commissioner's office and takes out charges, that would preclude a warrant under the bill text as proposed. But if they were to call the police arrive, they review the text messages, they interview witnesses to sort of conduct an investigation and fulfill the sort of traditional criminal law gatekeeping function, I suppose you can say. And they say, hey, there's something to this, we need to move. The police can take out charges and request a warrant. So this basically really only applies to complaints taken out by non-police officers, non-state's attorneys. And so in the circumstance you're describing, individuals would still be able to, access the criminal legal system in a way that would remedy their concerns promptly. It just requires the involvement of the institutions we typically trust to serve gatekeeping functions. These carve-outs, I think the Maryland State's Attorneys Association had really envisioned these carve-outs, particularly for victims who, for one reason or another, are concerned with bringing their issue directly to law enforcement or to the state's attorney's office. That if a victim doesn't feel safe going to the police, doesn't feel safe coming to a prosecutor's office, that they can still go directly to the commissioner's office. And if it is a, if there's probable cause to believe a serious enough crime has occurred, then a commissioner would be able to issue a warrant under the proposed amendment we see on the screen here. But that was sort of what animated the suggestions from the State's Attorneys Association.
All right, we'll roll back to Delegate Grammer, and then if any other members who haven't spoken want to weigh in on this aspect of the bill, we'll do that. Delegate Grammer and then Delegate Boucher.
Yeah, thank you, Mr. Chair. Yeah, so that's the baseball example is not actually one I'm thinking of. The example I'm thinking of is the situation in my district where two young gay ladies actually used this process at one point. It was a bigoted neighbor. The situation is crossing property lines. It's becoming a property issue. There's proximity problems. The issue's starting to get physical. Those are the kind of people you start doing things like this. You start chipping away at this process that they feel like shit in the middle of these situations. They ask what's their recourse, and you point them to this commissioner process, and they say, oh, now my crime, I can't do this because my crime doesn't suit the law, the exception we've made. And frankly, I think it's kind of trashy, and it's excluding those people's ability to find justice here. I had a second thought that is fleeting. Yeah, I just object to narrowing it down like this. Yes, the second point. We spend a lot of money, and you'll very infrequently find me suggesting that we spend additional dollars. But this is the kind of thing where the rational step to me seems to be, if we're short people to step in the state's attorney's office to look at these cases and say, we need to have another pin or two here to consider if these are legitimate cases or not. I think that's actually the rational and reasonable thing to do here, and look long term and say, how can we actually ensure more clearly that the cases coming through the commissioner process are legitimate? We're just, if we accept this amendment, we're really just blowing up the process itself, and we're going to be to at least some degree go down a path of cutting people's concerns out of the process, and I just don't like it.
Delegate Boucher.
Thank you, Chair Moon. I have a big interest in this, having been through a horrendous divorce and was victimized by charges like this. But I want to make sure that individuals would still be able to go to the district court and the state's attorney to get ex parte protective orders, would they not?
I believe yes.
Thank you.
Anyone else have any comments on this narrowing of the bill as introduced?
Real quick, if I can, Mr. Chairman. Again, I don't want to belabor the point. Delegate Graham, I hear exactly what you're saying. However, in a lot of counties, and especially the city of Baltimore, people are misusing this over and over again. In fact, in states across the country, the district court commissioner isn't even that process in which you take out those charges. So I would caution us to say that I hear what you're saying, but there could be a reasonable effort to be made in this bill that we still allow those individuals to have the remedy that they seek, but also limiting those who are going to continue to misuse this process over and over again.
Thank you. And Delegate Grammer, again, I'm hoping we can get some consensus product moving forward. I hear your complaint, and I guess there was some compelling testimony about limiting at least some of the circumstances where a warrant could be issued, and I guess hopefully we're getting closer there. All right, I think we'll just do this very quickly then. I saw Lisa Jordan, and then we'll do Holland Brownlee, Dina Hauser, very briefly, please.
Thank you, Mr. Chairman. I we looked at this. I also discussed this with Lori Ruth, who was unable to be here today, and felt like this was a good middle road. I do want to just say that I believe Delegate Embry's suggestion about immediately notifying the state's attorney's office is a really good one. I agree with you completely, Chairman Moon. We're never going to completely make the system absolutely perfect. We certainly have situations where survivors of domestic violence have the batterer file criminal charges against them, and the system's abused there. But the majority of cases by far are cases where we're unable to get a good response from law enforcement, and this is really entree into the system. So from our perspective, this was a good balance, and we really appreciate the work on it.
Okay, Holland Brownlee.
Thank you. I'm a public defender, a felony trial attorney, but I'm in a small county, so I have a district court docket every week. With all due respect, this amendment will completely guts the bill. What you have here under subsection A, B, and C is these are the categories for which arrest warrants are issued. I can tell you right now, commissioners are not issuing arrest warrants on, a citizen coming in and complaining that somebody stole their iPad. These three categories are the exact problem. These are the categories that arrest warrants are being issued. I can certainly understand the concerns, but I think that, unfortunately, I think this bill goes nowhere if these categories stay as they are, because my understanding of what the purpose of this bill was is to address arrest warrants, and frankly, these are the categories that those would be issued. Commissioners are issuing summonses for misdemeanors, sometimes for second-degree assault, but in the vast majority, crimes of violence, no question. And so that's my concern here with this amendment. Thank you.
All right, Dina Hausner.
Thank you, Mr. Chair. I just wanted to echo what Lisa Jordan said, that this, I appreciate the work on these amendments. I do think that this is a good middle ground. The ability to have an arrest warrant issued by a commissioner is an incredibly important tool for the safety of victims of domestic violence. Unfortunately, I don't think that law enforcement has enough resources to be able to investigate every situation before they would be able to apply for arrest warrant. And that would leave victims in this limbo place of a great deal of danger. So if the bill is going to proceed, we are very supportive of the amendments and appreciate the effort on them. Thank you.
All right, and it sounds like maybe Delegate Embry wants to draft an additional amendment. All right, can we now pull up the shielding amendment? So this is Claire Rossmark's effort to translate the shielding amendment that was discussed at the hearing. I have this up on the screen and open it for any discussion. This would keep it off of case search until there's been a conviction, if it came through that process.
From Baltimore City states that we're 100% in support of this amendment.
We have a Delegate Sample Hughes.
Yes, thank you, Mr. Chair. As this is written, I like the amendment, but I just want to just double check in my memory as well. Maybe you can help. Is this where one of the persons that testified, and I believe it was a physician, was this one of the things that he had asked for? Because I think he was concerned about his job, where he was in a position of or actually, I think he was trying to obtain a job and saw that this was on his record, and there had not been any conviction. Is that correct? Would that be the scenario in which this would be beneficial to make sure that a conviction has not occurred, but it wouldn't show up on judiciary case search. Is that correct?
Yes, though I'll have to go back and, like, if we do the other amendment now and we exclude the domestically related cases, I have to think about how this is, if this is written in such a way that if this would keep that in or out of case search. But yes, generally, yes.
Oh, judiciary case search. Okay, thank you.
Just like the city state's attorney, I can support this.
Delegate Bartlett.
Thank you, Mr. Chair. One quick question. Why are we including the drug and alcohol treatment information or cases?
Sorry. Go ahead, Mr. Schellenberger.
So, Delegate Bartlett, I suspect it's because they want to make sure that the person has entered into that program and that people can monitor that. I'd be interested in Hassan or Debbie or Joyce.
And that's not the bill, to be clear. That's existing text.
Okay.
But it's an interesting question.
I think that's
okay.
I think that's originally why it was in.
Thank you, Mr. Chair. I'm sorry. I thought this was another amendment.
Yeah, it's the bolded text underneath,
Yeah,
or the
gotcha.
capitalized text underneath. That's what we're proposing to add.
Okay, thank you.
All right, let me put it this way. Is there anyone on this call that would be opposed to us putting this sort of language in, whether or not we do the rest of the bill?
I think it's great, Mr. Chair. This is Delegate Kaufman speaking.
Okay, so let's move on then to the penalty question. And why don't we, if we can, we'll go back to the amendment that came from the bill sponsor, the 1-year amendment first. Actually, can we see it in the context of the text of the bill? Maybe we just look at the bill as introduced, if possible. And if you want to scroll down to the penalty section. Yeah, there you go. So this is the false statement. Would go from, the bill is introduced with 6 months to 3 years and $500. And we have a sponsor amendment to change it to 1 year. We have a grammar amendment to add restitution. And we have a third proposal option, I should say, that actually Claire Rossmark came up with as she was reading the forms and noting that they already mentioned the penalty of perjury. She has conjured a third option to circle back to the perjury penalty. Chris, if you're able to pop that one up on the screen. Oh, right. And there was some possibility here of triggering some sort of state's attorney review of this type of dispute. So this is the penalty question generally. The bill as introduced was 3 years for false statements. There's an amendment for 1 year for false statements. There's this amendment to point back to the perjury penalty that's already contemplated. And then there's a grammar amendment to add restitution. And let's see, whose hands do we have? Delegate Eric Hand.
Thank you, Mr. Chair. Could you just tell me what's the burden of proof look like? So is it like if there's no conviction? Sorry, the words are a little tiny for me to read. how do we make sure that that somebody doesn't come in good faith and there's not enough evidence to convict, but we're not criminalizing that person. That's comment/question number one. Number two is that I would support taking it from 3 down to 1.
All right, Delegate Embry, Delegate Grammer.
Oh, me? So I like A, that sort of is a reminder that it's a perjury charge is available. B and C I'm just concerned about because what does it mean for a person to refer it to a state's attorney? I don't know. I prefer A alone without B and C, but I'm interested in what the state's attorneys think about that language.
And to be clear, Delegate Embry, you would leave the false statements penalty as is?
Yes, I don't have strong feelings about that. It returns it to 1 year, right? The amendment returns it to the original.
No, it's at current law 6 months, as introduced 3 years, amendment 1 year.
Oh, I'm sorry. Yes,
It's 3 options on false statements there.
I think I'd go with 1 year. I think I agree with the sponsor, but I don't have strong feelings.
Okay, Delegate Grammer, and then we'll hear from Patrick Gilbert.
Yeah, thank you, Mr. Chair. Just wanted to explain my amendment briefly. So any criminal charge, you can get restitution. What this amendment does for this particular charge, lying in the admission of these what would be false claims, it would change the way restitution applies in these cases in 2 ways. First is it would say that in this case, a judge shall make a determination of restitution. So the kind of claim that the people who had been fraudulently received these charges, the claim is, it essentially wrecked their life. And I think, criminal charges, whatever we decide to do with that aside, if there really is a, impact to this person's life, a judge should really step in and say, okay, you're going to pay restitution to this person and make this person whole. So it takes it from a may to a shall. Also, in the restitution statute, the maximum restitution there is $10,000. My amendment lifts the cap so that, if you've been put them, if the claims for these folks are true, they've been detained for several months, or they've had these damaging situations where they've lost tens or hundreds of thousands of dollars, a judge can order that they be made whole. And that's what the amendment does.
Right. Patrick Gilbert.
Thank you, Mr. Chair. I can try to address some of the questions. Delegate Aragon, your question, I think, was regarding sort of the standard of proof and whether if a defendant is acquitted, the court finds that the state hasn't established the proof beyond a reasonable doubt, whether perjury charges would automatically flow or sort of how that operates. My read of this amendment doesn't compel the institution of perjury charges upon an acquittal on the underlying commissioner complaint charging document. I think it's subject to the same sort of analysis that any criminal charge would be as drafted. This amendment would, upon a referral to the state's attorney's office, require an investigation by the state's attorney's office and the requirements of instituting or pursuing perjury charges if appropriate. And so that would be just your standard sort of probable cause to believe a crime has been committed in order to charge a case, and then it would be, proof beyond a reasonable doubt. A lot of times in practice, these cases are sort of very gray. It's all in the middle. And so, anecdotally, a lot of these cases are very difficult to prove one way or the other. To Delegate Embry's point, I think I would, of course, I'm not an elected state's attorney. I'm on the legislative committee, so I don't want to overspeak. But I think that the State's Attorneys Association would probably be in support of A only. Generally, the association doesn't like the sort of compelled investigation language that you see in B or C. But I think A is certainly something we would support. I defer to State's Attorney Schellenberger on that point because he is an elected state's attorney in a way that I'm not. And finally, To Delegate Grammer's point, I think Delegate Grammer, you've honed in on a really important issue, which is that the issuance of warrants in these types of cases is extraordinarily disruptive to an individual's life, right? You spend a weekend in jail and then, bond review on Monday morning. And even if you've been released, you've been processed, you've maybe lost your job, you've spent a weekend away from your family. It's extraordinarily disruptive. I would suggest to the subcommittee that the use of restitution might be too narrow a remedy to address the type of harm that you're trying to capture, Delegate Grammer. Restitution in the criminal context tends to be very sort of restricted to the issue. And I think what you're contemplating more is like non-economic or economic damages in a civil context, which might be able to make victims of abusive commissioner complaint warrants whole in the way that I think you envision, Delegate Grammer. So I'd suggest that to the committee to consider if that's something that the subcommittee would like to pursue.
All right, Mr. Schellenberger, and then we've got Delegate Cardin.
Yeah, actually, I agree with Mr. Gilbert. 1 year plus restitution, I'm okay with both. I too believe A is the best process. I don't think we need to remind state's attorneys that under the right facts and circumstances, oh, by the way, there's another crime called perjury. I just don't think that's necessary. The whole concept of this is to call out a different kind of crime than perjury. Now, some of the elements may be the same, but it's a little bit different. And so I do think 1 year plus restitution is fine, and leave A in. I don't think B and C are necessary, and it might create complications.
All right, Delegate Cardin. You are on mute.
Hi there. Thanks. So I was just before Mr. Schellenberger commented, I was gonna comment that I have never seen restitution without a state's attorney specifically asking for like receipts and expenses so they can have something to show. Now, I could be wrong about that, but it would seem to me that if we're trying to make people whole, I don't know whether there needs to be additional language, but it seems like you do need something that would be analogous to non-economic or economic damages.
Well, Delegate Cardin, just to answer that directly, my vision is, I had to hire a lawyer and I paid him $5,000. And you're going to have a check or a bill that's going to show that. So that's kind of where I thought this was going.
Right, but I thought that I agree with you. That's great. That's the one where you can show the receipt. But what Delegate Graham was talking about was more of, and this is for the chair, was more of, my life got turned upside down. I lost the ability to make my living. Like, Scott, can you, if I showed you that I normally get paid $25 an hour and I miss, 10 hours of work, is that restitutionable?
Absolutely. I think that would be perfect.
Okay. Well, I just want to make sure that we're not making it more narrow, as the gentleman said before, and giving people an opportunity to get everything that they should have coming to them.
Yep.
Delegate Grammer, do you have a final thought?
Yeah, just wanted to say, to my understanding, typically, when there's restitution, the judge isn't necessarily automatically inclined to offer that. It's typically a situation where someone asks for restitution, a state's attorney motions for restitution, and in those cases, you're going to have to convince the judge to do so, which you would be required to have some kind of evidence.
Right.
I will go ahead.
The state's attorney is pretty good about asking those questions. They want to make sure that they're protecting their witnesses or their victims.
Yeah, 100%. I just think in this case, if a judge understands that they have to do this, they'll likely be looking at how has this person been, impacted? What you and Scott were talking about previously, and that's why this is structured this way.
All right, so I'm gonna quickly sum up and we'll give the sponsor a quick second. Oh, hold on. All right. Christine Dufour, do you have a quick comment on this?
My question is, what would be the vehicle or hearing in order to seek restitution? If the charges have been dropped and you're then arguing that they never should have been brought, it was a false statement, what hearing exists afterwards?
Mr. Gilbert, you wanna? Looks like you raised your hand for that. No? Oh, okay.
Thank you, Mr. Chair. My read is that it would only be upon a conviction for the false statement to commissioner offense.
Okay,
Correct.
so that would be way down the road. It's not just my charges got dropped and I now think, the complainant lied in the citizen generated complaint. There would have to be a conviction. Okay, that would make sense then. Thank you.
Okay. And do we need to add anything to the bill per Delegate Embry's suggestion on a rapid notification of a commissioner charge to a state's attorney's office? Delegate Embry, did I hear that suggestion correctly?
Yes, it would need to be added. And that would not have a time frame, so it doesn't trigger the issue that the State Attorney Schellenberger raised, but it would still at least give state's attorney's offices that want to the ability to quickly recall and quash warrants.
Yeah, I believe Delegate Embry's suggestion is a great one.
So, if I may attempt to sum it up, I'm hearing 1 year on a false statement penalty plus restitution. We hope that includes legal fees, a rapid notification per Delegate Embry's suggestion to the state's attorney so that they can recall some errant submissions if needed. And this part so far sounds a bit consensus to me. And then we're on to the meat of the bill, which is a question about whether we do something closer to the bill as introduced, whether we do in fact narrow out the offenses. And there are folks that are specifically requesting that we not narrow the crimes of violence out of the bill. And so I will say we can all sleep on the meat of the bill for a week and we'll turn back to it next week. But unless anyone objects, we'll plan on getting moving on the 1 year restitution, rapid notification, the shielding. Oh, and that perjury language from A, that these are under perjury at application. And then we will kick around what to do on the meat of the bill. And hopefully we'll plan to vote on that aspect of it next week. And I see a final hand from Holland Brumley. Final thought here.
Hi there. Sorry, I'll make it quick. I just wanted to be clear on behalf of the Public Defender's Office. We can't strictly get behind suggestion to raise a penalty if it was 6 months and now it's going to be 1 year. That's still raising the penalty. And we can't officially get behind this language regarding the perjury, if only because while I do think it would help a number of our clients who find themselves in this situation and want to have some vehicle to address with the state's attorneys, I could see another great portion of our clients affected by now a state's attorney's office being specifically tasked to pursue perjury. So I just wanted to make that clear for the record.
Yeah, and
Thank
I
you.
think with what you're seeing on the screen, it sounds like we're just talking about A and not the B and the C.
Gotcha. Okay, thank you.
Yep. Great. All right. Let's move on to the next bill, which is Delegate Crutchfield's bill. House Bill 437, I believe this was. Do I have that bill number right? So
Yes,
this
that's
was a bill about visual surveillance with prurient intent in a place where someone has a reasonable expectation of privacy The bill has an existing law has an enumerated list of places as well as a catch-all where visual surveillance is not allowed. So I honestly don't have a strong feeling on this bill. I actually went back and reviewed the the hearing and can see both sides of this. Language that perhaps could be clearer in the law. And perhaps it's also true that there may have been an alternative charging mechanism and the random behavior of a judge. But so I think there are good points on this. We'll open it for discussion. And Chris, do you want to put on screen the bill text, a pretty short bill, so that we can be looking at something as we get the conversation going? And I just to refresh the committee on the sort of pro and con from the hearing. Here you can see that in existing law, private place plainly does not include a residence. But if you scroll down a little bit, and if you keep going, here you go. You get to C2. The opposition testimony was suggesting that C2 may have covered the circumstances described for the need for the bill. But like I said, it's not in, whatever, so if it's covered, if it's covered in C2, I don't see the harm of adding it to the other section. So I kind of see this both ways, but let's just open it for discussion. And Chris, do you want to scroll back up to the list where we are, where we're at the meat of the bill? And let's start with committee members. I'll start with Delegate Kaufman, and then we'll roll back to Delegate Crutchfield, the sponsor. Delegate Kaufman.
Thank you, Mr. Chair. I was on mute. I'm very much in favor of Delegate Crutchfield's bill because I could be getting the bill wrong, but I'm still struck by the fact that this woman's roommate who testified said that her roommate took pictures of her for 15 months when she showered, but it was the bathroom when the residents were not considered a private place. So I think even if the opponents are right that C2 takes care of it, it's clearly not doing the job because you had all those witnesses telling really, really disturbing stories. So I hope, if we get to a vote, I will be voting in favor of this because I think it's a critically important bill, and I commend Delegate Crutchfield for introducing it.
All right, we'll then hear from Delegate Crutchfield, and then why don't we do this in alternating so that we get a little bit of discussion here, and then we'll have Holland Brownlee and then Debbie Feinstein.
Okay, thank you very much, Mr. Chair. I just wanted to raise the fact that there are now amendments to the bill, and those amendments do clarify a little bit of the discussion that you raised earlier. And I can send those amendments. I've just gotten them back. For example, the First Amendment would actually clarify the title so that it is visual surveillance with prurient intent modifications. And then it goes into a little bit of detail about, what this really does. It alters the prohibition against conducting visual surveillance with prurient intent. But it also takes care of that other section that you just raised, which was C2. At the end of it, where it actually talks about that, you can go directly there. At the end of C2, there's line 13 and line 14, the change would be to take out whether the individual is in a public or private place and instead put in there the location of the individual, regardless of the location of the individual. So that kind of straightens up the earlier information that you had raised about the bill.
And sorry, do you have your amendment in
I do.
the way you can share it? Can
Yes.
you email it to C. Daniel at the House address.
I can do.
Chris Daniel, and then we'll get other people talking, and hopefully we can get up on the screen while
Okay,
that is
I will
happening.
do that.
All right, so let's go to Holland Brownlee, and then Debbie Feinstein, and then John Carden.
Thank you. So I'm really glad Delegate Crutchfield brought that up. I did happen to look at that as well, that the Senate had made an amendment change. I think the change changing it, the second part to the location of the individual, I think that would certainly address any concerns with interpretation, because I'm thinking when I think back on this and the hearing, I think that maybe what a judge could say is, well, if we're saying that private place has this particular meaning in the statute, then the language public or private place, it's not exactly clear what that means. I think maybe the original legislative intent might have been to cover everything, but this amendment that is in the Senate, as Delegate Crutchfield said, I think would address that concern. The other thing I just want to say is that the first section there where it lists all those places, those are specifically public places where the legislature has said, hey, here's a public place that has a private element that somebody might be disrobing in and has this expectation of privacy. Well, I mean, I think a residence, you always have that expectation of privacy, but the difference between that first section and the bottom section is this. The bottom section specifically says that the surveillance has to be of a private area. And that's what's so important here, because if somebody's conducting surveillance of somebody in a bathroom of their home, in a, of a private area where they're going to be naked, presumably, that certainly is something that should be covered under that second section. But if you open up residences to that first part and put in just that if there's a camera in a place where somebody could be disrobing and you're including a residence in that, I think you're opening it up to lots of potentially different things involving ring cameras, nanny cams, and things like that that are going to be unintentionally included. And that's why it's so important to limit that. That's why that area, that first part of the statute is so important, that it limits private places in public. So to my mind, that amendment from the Senate, I think, would clean up any problems in interpretation. I worry about putting residents in that first section because I think you potentially could cover a lot of different scenarios where it's innocent conduct. So that's all I want to say. Thank you.
Debbie Feinstein, and then John Carden. Sorry, you were on mute.
Thank you. I'm so sorry. I thought I unmuted. I apologize. Start again. Good afternoon, Delegate Moon and members of the committee. And I first want to thank Delegate Crutchfield for bringing this bill forward. The case that we've been referencing was a Montgomery County case, and some of those facts were shared. I appreciate the Office of Public Defender's comments, Ms. Brownlee's comments, that she is okay with the second part, and that is consistent with the amendment that was made in the Senate. So I won't go there, but what I will say is that residence absolutely belongs in little one under the definition of private place, because the statute could still be construed even with the change in the second part to exclude a residence. That's what our judge did. Our judge said that I'm going to keep looking back at the definition of private place, and it's not on that list, I'm not going to count it. And I suspect that would happen every day of the week, even under the change that's being proposed with location of the individual, because of that, definitive list of places. I would point to another section of the code that addresses, I think, what Ms. Brownlee's concerns were. It says that this section does not apply to a person who, without prurient interest, conducts or procures another to conduct visual surveillance of an individual to protect property or public safety or prevent crime. That's going to be the person that puts up surveillance cameras within their house to try to prevent crime from happening, or a nanny cam to make sure that their child is okay. we still have to establish prurient interest. We're not going to be able to do that in circumstances where there are these regularly placed cameras. It's still going to apply in those situations. This law is only going to apply in those situations where we can prove prurient intent, and not just sort of a general surveillance of one's own property for protection. This statute specifically excludes that. So that's why we believe, why the State's Attorneys Association believes, and based on the case that I described, why my office strongly believes that a specific definition of private place belongs of residence belongs in that 5(1), because it's not included now. And there's nothing in that 5(1) that says anything about all of these places being public places. I mean, there's a list that on the list includes family child care home. So that's where the judge landed, is that it wasn't included, and therefore we're not going to convict this defendant. And I will tell you that in conversations with the Maryland State's Attorneys Association Special Victims Subcommittee, this was not the only example. It was the example that came from Montgomery County. There were several others under similar circumstances where the fact that it was in a residence resulted in a not guilty. Those state's attorneys were just not available to testify this year. And thank you for your consideration.
Delegate Cardin.
Thank you, Ms. Chair. And Ms. Feinstein said it much more eloquently than I could have, but I wanted to just ask, maybe she can answer a little question. So you have to prove prurient interest or prurient intent, which to me seems like it doesn't really matter how wide a net you cast. If you can't prove that, then it doesn't really matter. But does the statute specify how and when? I can't read it. My eyes are no good. I'm on my cell phone. I apologize. But does the bill or statute specify how and when you have to prove the prurient intent, and what the standard is? And if it does, then I don't see why we should worry necessarily about, casting a broader net.
Can I address that, Delegate Moon?
Yes.
If you look at subsection 6(3) or little Roman numeral 3, it says visual surveillance does not include casual, momentary, or unintentional
Scroll down. Yep.
observation. It also says under 6(1), visual surveillance means the deliberate, surreptitious observation of an individual by any means. When we're talking about a ring cameras are typically not surreptitious. It's not something that's deliberate to become sort of that next step with respect to prurient intent. There's all sorts of protections baked in into the statute, but that was including what I had described a moment ago, B, someone without prurient intent, 2, conducting or procuring the visual surveillance to protect property or public safety. Those circumstances, we're not going to see surreptitious and that sort of thing, and we're not going to be able to prove prurient intent. I mean, I guess the example would be what the nanny changes her top in the child's bedroom, where the child is sleeping, and the nanny cam captures the changing of the top. Well, presumably I think number one, the nanny cams are typically visible. Of course, they probably aren't always visible, and people hide them in teddy bears and all that sort of thing. But we'd still have to prove prurient intent, that the aim was to catch the nanny who happened to change her shirt in that bedroom, versus the fact that she did it on that particular day. If there's a pattern, if there's many, many recordings where it keeps coming up that this nanny cam keeps capturing a naked nanny in this bedroom, I think we have a problem, and we are going to look at prurient intent. But sort of that unintentional, non-surreptitious, non-prurient intent.
Can I just ask another question then?
Of course,
so
I'm sorry.
If you happen to be taping and the nanny is actually doing something else nefarious, but not having you're trying to capture her stealing something, or playing with your computer when you told her she wasn't allowed to play with your computer, or something that is wrong, but it has no prurient intent, then it all of a sudden becomes undiscoverable. Is that correct?
No, because we would because as long as it's, you can't record someone under the wiretap statute when they're not aware that they're being recorded and you have the audio on. So if there's audio on, we could have a problem. If there's no audio on, which if there's a nanny cam that's monitoring without audio, that's not visible, because if it's visible, there's no wiretap problem. So, but if it's for some reason not visible and we could strip the audio from it, we could use it for a theft charge, for example, evidence of a theft charge if it's otherwise admissible, but we couldn't use it again under visual
Right.
surveillance.
But the question is it otherwise admissible if we are casting, this is what I think this is where the public defender was going. I'm concerned that if we're doing this for the purpose of the prurient interest, we're creating a larger net, then it should only be for that interest. It shouldn't be for other, purposes that you want to create evidentiary testimony.
This shouldn't extend to a larger evidentiary net. It's very limited to this statute. Any concerns about a larger evidentiary net would have already been happening. Just adding private place isn't going to change that dynamic. It would change the same dynamic in a dressing room.
Is that the intent of Delegate Crutchfield? Is this is only for the prurient purposes versus doing something else that's either illegal or disallowed by whomever is trying to?
I would just say that there's all sorts of other statutes that would govern that type of conduct, but I obviously don't want to speak for the intent of Delegate Crutchfield.
Mr. Chair, may I address that?
Sure, and I'll just say it says pretty clearly to protect property and what have you in the law, but go ahead, Delegate.
That is correct, Mr. Chair, and that is exactly what I was going to say. It is very, very limited in scope.
Okay, great. I just want to, I'm good. Then I don't have a problem with expanding it. I mean, looking at it from a criminal defense attorney's aspect, as long as it's for the narrow purposes of this really, really heinous, type of.
And Delegate Crutchfield, can you clarify, is your amendment instead of the rest of the bill, or is it in addition to adding residents to the list?
No, it is just modifying, just adding what's stated.
It's in addition to your bill.
Yes, that is correct.
Yeah. Okay, got it. All right, sorry. We'll go back to Holland Brownlee quickly and then try to do a summary wrap.
Delegate Coffin tasked me at the hearing with coming up with a scenario. And I think Ms. Feinstein has helped me kind of clarify one. I have a babysitter at my house watching my kid. Maybe I have a little teddy bear nanny cam set up in the living room. I see her smack my kid. She comes home, I pay her, and I say, hey, I saw you smack my kid. I would rather you didn't do that. And she's like, OMG, I changed my top in that room. She's marching herself down to the commissioner's office where she can easily obtain a citizen complaint against me for visual surveillance with prurient intent. Does it stick? Maybe, maybe not, depending on what she comes up with, depending on what my nanny cam shows. But the bottom line is anyone can go in and swear out charges on anybody. And so whether or not you can be found guilty, it doesn't prevent you from being charged with these items. So I think that's where my concern lies. Additionally, I just wanted to let everyone know, I did watch the Senate hearing. I did see that victim story that we heard from about Ms. Quaitman, I did see it came out in the Senate hearing that gentleman in that case, he was convicted of stalking and received a 5-year sentence, suspend all but 1 year. I'm not sure if the House heard that information, but the Senate heard that information. Thank you.
All right, Delegate Crutchfield's final thought here.
I just wanted to respond to Ms. Brownlee, and I think the key statement you made is that anybody can square out right now anything against anybody with the commissioner. And as we know, that's in a separate bill that we need to take up.
All right. So there you have it, folks. It sounds like folks are in agreement with Delegate Crutchfield's amendment for what it's worth. And so like the other bill, we'll have a discussion and a vote next week on the remaining substance of the two bills. And now you have, yes, Delegate Schellenberger, do you have a NSC Delegate
A
Sample Hughes?
promotion. Yeah, I got a
Let's use-
promotion, Delegate Schellenberger. Do you have another subcommittee meeting at 4, and can you use the same Zoom link?
We probably,
I think
do
public
not.
safety is meeting at 4 o'clock is what he means. Nicole's subcommittee.
You're right. I'm sorry.
Delegate Sample Hughes.
Thank you.
Thank you, Mr. Chair, and I'm glad we're still within this session of the discussion. I have a quick question for probably state's attorneys. And this is in relation to the first bill, when an officer has, the body camera footage in a situation that has occurred, does the commissioner have access to view that before making a decision? Or is it only the state's attorneys that are allowed to view the body camera footage to make certain decisions as it related to that first bill? Who has access?
Well, I can tell you it would be very unusual to actually play body camera for the commissioner. If the officer's taking out the charges, then they may actually be able to replay their body camera video. But I believe it would be just very unusual. There's nothing to prevent it. It just would be unusual.
Okay, I was just checking to see if that would be a part of their decision-making process.
And I'll be happy to hear from Ms. Feinstein if she had anything else to add.
May I, Delegate Moon? Thank you. I was just going to add, I haven't heard of a circumstance where the commissioners have access to body worn camera. It's actually a whole process for my office to even get access to body worn camera. So I don't think that's really part of the equation when going in front of the commissioner, either for officers or for members of the community. I can tell you then when the case comes to my office to review, we will look at it. But I don't believe the commissioner typically looks at it. It would be highly unusual based on my experience.
Okay.
All right. Thank you, everybody. We will be back next Monday at 2 p.m. And I guess we will plan on voting on amendments and bills.